The Supreme Court of Canada has issued a ruling on privacy and the police, saying that Canadians should have a reasonable expectation of privacy for their IP addresses. CBC's Kate McKenna is following this story, and she joins us now with more. Kate, this ruling, it finds that the internet is changing the way the courts must interpret the Charter. What can you tell us?
Hillary, this ruling is only a little over an hour old, but it's already being described as a landmark ruling. The courts were forced to grapple with whether or not an IP address, so a number that's assigned by an internet service provider to individual computers that browse the internet, whether or not that information alone, when attached to an identity, constitutes an unreasonable search and seizure under Section 8 of the Charter. And ultimately, the Supreme Court found that yes, that information is enough information to be what they call a breadcrumb on a trail of information that could tell police or third parties such as Google or Meta a lot of information about an individual. And so they're saying that that in the future, police will have to get a warrant in order to find out someone's IP address. And of course, this is being called a win by civil liberty groups that wanted this ruling. This ruling was not the same ruling as two lower courts. This originally stems from an Alberta case that looked at a man who was accused and ultimately convicted after allegedly using credit card information, fraudulent credit card information on the internet. He argued, or his lawyers argued, that that information should not have been found without a warrant. And the two lower courts, the Alberta Court and the Court of Appeal, ruled that the police were justified. Well, now the Supreme Court is ordering this man should have a new trial, and also setting this precedent that in the future, police will need a warrant in order to get someone's IP address.